There's some very exciting news about the Camp Lejeune Early Resolution Program, a program that enables veterans who served our country, Marines who did the right thing, who are stationed at Camp Lejeune, can receive up to $550,000 in compensation, and it will not affect your VA benefits one bit, according to the resolution program. I want to go over all the details and also offer the opportunity, if you have a question, to speak with our firm at 877-561-0000. We handle these cases purely on a contingency basis. If you know me and my background, you'll know I was stationed at Quantico for over 4 months of my life. I'm very close with the Marines and certain individual Marines. We love to help, we love to answer your questions, and I work with a dedicated team of lawyers and admins that really want to help you and fight for your rights like you fought for the country. And unfortunately, we're betrayed when the government knew that the water at Camp Lejeune was bad and still let people drink it and use it for their laundry and things along those lines. So let me break down a little bit what the Camp Lejeune settlement, who's eligible, and what it encompasses. First of all, it has to do with Marines that were stationed there or other individuals who were stationed on the base from 1953 midway through it to 1987 who served at least for 30 days there. So that's the minimum amount of time that you need to establish you're there. You could establish that through the military records, which we can send away for, and there's also alternative means which we can discuss that may be more challenging, but it is worth a shot if you in earnest believe that you were there. The settlement values as they stand in the early resolution program are from $100,000 to $550,000, and they depend upon what tier of injury you have, and unfortunately, whether or not somebody is passed or not, and we'll get into the different breakdowns. It will not affect, as per the terms of the prospectus that's been released by the Department of Defense and Department of Justice, it will not affect your VA benefits one bit. And this is an important footnote that we'll get back to in a little bit, because it's our recommendation that individuals avail themselves of the early resolution program. There is a potential for you to receive more money if you try your case, but there's always a potential for you to receive less money also at the end of the day. And also, since this program guarantees that there will be no offset based upon your benefits you've received, it's a lot different than if you wait 2, 3, 4, 5 years to have your case tried, get slightly more or even a lot more, but as per the statute, if the VA benefits that were prescribed offsets what you ultimately obtain in the future, and that's if you win your case, because that's always a chance that you won't win your case, then you then offset it by whatever was paid by the VA, and you might be back to these numbers or even worse. My guess, one of the questions, when will this be paid? Everybody knows, because you've all dealt with the government before. Government's a lot about hurry up and wait. Just like I predicted, there would be an early resolution program for the Marines that have served and others that were stationed on the base. I also kind of predict with my crystal ball that they're going to try to get payments out in late 2024, right before the election. Just a sneaky suspicion. I've been right before, but I've been wrong before. So there is a lot of upside to participating in the program right now and trying to get the paperwork filed as promptly as possible before everybody else starts to file it. There's already, I think, as of today's video, 93,000 plus claimants, some of which is represented by my firm, Brown LLC. So let me break down what the settlement values are, and I'll talk to you about it. And if there's any questions, again, please give our firm a call. For people who have certified medical records of Tier 1 injuries, and they've classified Tier 1 injuries based upon causation factors about the substances in the water that are strongly tied into these type of signature injuries. And the Tier 1 injuries I'm referring to are kidney cancer, liver cancer, non-Hodgkin's lymphoma, leukemia, and bladder cancer. And that's it. That's the only Tier 1 that are eligible for the early elective resolution program. For Tier 1, if the individual is there between 30 days and 1 year, it's $150,000. If it's from 1 year to 5 years, it's $300,000. And if it's 5 years or above, it's $450,000. Now, from our experience, most people were at Camp Lejeune for less than a year. Some people, of course, had orders and were stationed there much longer or had gone through there for more extended periods of time. But your records will speak the story about the proofs in that. Also, bumping up from those numbers, unfortunately, people that have passed is an additional $100,000. So the estate can claim those numbers plus $100,000 if they are, or the individual is a due representative of the estate. For tier 2 injuries, and here's the tier 2 injuries. Again, how do they define tier 2? They do long-term studies about exposure to the carcinogens in the water, what conditions they cause, just like with the tier 1. The conditions are multiple myeloma, and let me say that again, multiple myeloma, not melanoma, not the skin moles that are removed. Those are not eligible, or at least not at this point, and may never will be. But the multiple myeloma condition, Parkinson's disease, kidney disease with end-stage renal disease, systemic sclerosis, and systemic scleroderma. And the numbers for those are, settlement numbers for those are, individuals are there from 30 days up to a year, 100,000, from 1 year to 5 years, 250,000, 5 years and above, 400,000, additional 100,000 for those families that had a loved one that have passed on as a result of passing from the signature injuries related to the litigation. There's also another portion of the case that you have to establish, and that is the latency period. That is the injuries, the cancer that happened, or the other condition that happened, had to happen within 35 years of the last point that you were stationed or present at Camp Lejeune. So this creates a little tricky paradigm. The tricky paradigm is that a lot of times medical facilities don't have records for extended periods of time. VA hopefully has them, or there's a reference to them in the records. But for example, somebody stationed in 1960, you'd have to be diagnosed by 1995, if we do the math correctly, in order to be eligible for this program. What if you were diagnosed beyond that 35-year latency period? We're still holding on, filing those claims, and maybe we'll obtain a ruling in court at some point, or a jury will come back one way or the other. Then you get into all sorts of other factors, which again is a reason why we advocate that if you're eligible to participate, you should participate. Other factors. Can you do better? Yeah, you could always do better, but you can always do worse. When you wait for longer periods of time, there's uncertain results. There's individual causation factors. If you have to litigate, for example, do you have a family history of cancer? Were you exposed to other carcinogens? Have you participated in other settlements for some of these signature injuries? For example, non-Hodgkin's lymphoma. Did you already avail yourself of a Roundup settlement? Things along those lines may play a part the longer the litigation persists. So our strong advice, get in while you can. If you have questions, give us firm a call, 877-561-0000. You've done so much for the country. It's time the country does a little bit back for you. Call us. We'd love to talk to you about what your options are and see how we can help. Thank you, and thank you again for your service.